Welcome back, everyone, to LMI Podcast, Lawyers, Mediators International Show and Podcast, where we talk about the law and conflict resolution topics to educate both professionals and everyday people. Today, I am with special guest Felicia Harris Hoss, who is a mediator, arbitrator, basically all-around guru on all things ADR, and soon ODR too. Felicia, welcome.
Thank you. Such a pleasure to be here.
Thank you so much.
Yeah.
And so we're going to get started, guys, to educate you about what you do, Felicia, which is what we're passionate about,
Right.
which is helping people resolve conflicts so that they can stay out of court. But because of your tremendous background, I wanted to just interview you and just have you share some of the things that people should know out there. All right. So Felicia Harris Hoss is a premier mediator, arbitrator, and settlement advocate based in the greater Houston area. With a career spanning nearly 3 decades, she transitioned from a #1 in-class graduate at South Texas College of Law and high-stakes litigation partner to a full-time independent neutral. Felicia is a fellow of the Chartered Institute of Arbitrators and a credentialed distinguished mediator. Her leadership is recognized across the industry, currently serving as the budget officer of the ABA section of dispute resolution and a member of the State Bar of Texas ADR Council. Now, beyond the law, Felicia's background in journalism and her service as a Pearland City Council member and Mayor Pro Tem provide her with a rare depth of perspective on public policy and human communication. Welcome to the show.
Oh, what a warm introduction. Thank you so much.
Yeah.
That was very gracious.
Yes, no, absolutely. And like for some people, whenever I do my pre-show prep, I find out more about that. I'm like, wow, they're a pretty big deal, and I gotta have this person on. So thank you so much. I didn't know you were in Houston, actually.
I know when you reached out, it was so great of your idea to get together in person instead of doing it remote. I loved it.
Yes. And actually, we are in the Texas Justice Center.
Yeah.
Just wanted to give a shout out.
Do it.
Because we're both officing here now. And I used to be at the Heights Mediation Center, but now I'm at the TJC. And so both places are great, but I like this. It's out in Bel Air, and folks should check it out. And it's definitely a place to be to do mediations in person, hybrid, or on Zoom if they have the equipment set up.
No, it's a great facility. There's free parking, great Wi-Fi, and you don't know what other mediators you're going to bump into in the hallways. It's a great place to hang out and get to know your colleagues.
Exactly.
Share ideas.
Yes. And so I've actually mediated with, as an attorney, I have mediated with mediators here.
Yeah.
And now I'm on the other side doing my own mediations.
I bump into some of the mediators that I, hold up on a pedestal and want to be like in the hallways here. So it's a nice place to be.
Exactly. Okay. So let's start talking about something I saw on your website, and I will share your website on the screen post-editing, but the rise of settlement counsel.
Yeah.
So what is it? And just educate us about the strategic advantage of law firms and hiring dedicated neutrals. What is settlement counsel?
Sure. So settlement counsel actually is an advocate, not a neutral. Okay, so let's take a hypothetical. You've got a really big case and very complex, and you want a lawyer who is experience in that area of the law to help just resolve it, right? So they come to the dispute with a different mindset, right? You have your trial counsel who is focused on gathering the evidence, strategically positioning that evidence, the witnesses, et cetera, for a potential trial. The settlement counsel is someone who, again, is an advocate. They'll participate in the mediation, but they won't appear in the courthouse. They won't have their name on the pleadings. They won't be in that role in a deposition or elsewhere. So the benefit there is they're not distracted by the trial.
Sure.
Their viewpoint is solely what is in the best interest of the resolution here versus what do I need to persuade strangers in a box, the jury, about. And as you know from your mediations, the audience in a mediation is different than the audience in a courtroom. It's the other side. So it's a way of sort of segregating the responsibilities. I personally have experience getting ready for trial and having the other side call me as I'm doing that consistently. Maybe it's an associate. And I always chuckled inside saying, oh, they're just trying to distract me from getting ready for trial. So if you're in that situation where you're getting ready for a big trial and you feel like you want to focus on the trial and have someone else focus on settlement, you can even bring settlement counsel in later to handle that aspect of the case. But really, they're a strategist. And for early mediation, there are strategists that you might want to involve so that you can delineate the roles early and do an early case assessment with someone who is not looking at the strategies going to trial, but have another person looking at the early case assessment for the trial strategy. And, it's the team members, another person on the team. They don't have any control in the courtroom. Their control is in the mediation room.
Gotcha. Would settlement counsel, I guess, cost the party who's using them a bit more?
Well, they're an advocate, so they're paid differently, right? As neutrals, we can't take an interest in the case that way, right? We get paid by all parties. They get paid by one party. And so there are all sorts of ways. You can use alternative fee agreements with settlement counsel with incentives and success fees or whatever, just like you would with a trial lawyer. So they can work on an hourly fee, same model as you would for a trial lawyer.
Yeah, I'm hearing echoes of collaborative law a little bit in settlement counsel.
A little bit.
Yeah. So before we move on, I know you've done a lot of work with the ABA.
Mhm.
And last spring, I was at the Dispute Resolution Section Spring Conference. And is that every year or was that every other year?
It happens every year, although this year it's not happening.
Yes, that's why I asked. And so I missed you there, but I was there, bought the podcast on the road.
I was there. We just didn't see
Yes,
each other.
exactly. That's what I meant. But just tell us a little bit briefly about your background at the ABA.
Sure.
I mentioned it, but on LinkedIn, I'm a big person on LinkedIn. I've seen your name come up a lot at the ABA. Just can you give us the Cliff Notes version?
Absolutely. So I got involved in the ABA when I pivoted my practice out of the courtroom and into the conference room, and started doing some work with the EDR committee, the Early Dispute Resolution Committee, and that just grew. And over the last 4 years or so, I was a council member, and then I was asked to consider moving onto the executive committee, and now I'm in line to be chair of the section in a few years. So, and a lot of that just stemmed from showing an interest in, being reliable, I hope, and the EDR resolution, the work there, working with the team on Ensemble when she was chair, to get that passed. Jen Mickle, who is our staff liaison, it's a lot about showing up and a lot about showing an interest. So anyone who wants to get involved in the ABA, contact me. I'm happy to help you get involved.
This is actually kind of important. I know a lot of lawyers who kind of don't bother with the ABA. Mm-hmm. We have our local bars at the state level, and a lot of times we're already paying local dues for local bar organizations. Right. What are some pros, some reasons why people should get involved?
There are some wonderful local bars, which you and I are members of. The pro to the ABA is that they have a national presence, right? And so and their programming is really exceptional when it comes to the substance of the law and strategies. And really, one of the best things is collaboration with other professionals across the country. Yeah. That really is probably the hallmark of the ABA.
No, I agree. I met a few people from Washington State, folks in North Texas who I didn't know. That's only because of the national bar. Yeah. Okay, let's talk about early dispute resolution.
Great.
So early dispute resolution, EDR, it's something that, again, I found that you talk about. What is it and what are some of its benefits?
Okay, so I'm passionate about early dispute resolution. So let's first talk about what it isn't. It's not an event, right? Normally, we know, all of us know that less than 5%, some say less than 3%, others say less than 1% of cases that get filed go to trial. Yeah. Most cases that go to mediation end up resolving either during the mediation process or sometimes shortly thereafter. So what early mediation is it's not an event. It's not you go to one day and you hope you get the case resolved. It's a process. And it's a process that you should engage in before the lawsuit gets filed or early after, or an arbitration, And there's actually 4 steps to it.
Good.
The EDR mediation process. You want me to walk you through? I'm happy to.
Absolutely.
But first step is, let's take a hypothetical case gets filed, or you're about to have a case filed, and you have a contractual provision that says you have to mediate before you can file a lawsuit.
Mhm.
We know that a lot of times it's just to check the box because I don't know enough information about the case. How many times have you been there where you're like, "Oh, my goodness, this is a waste of time because we're never going to know how to advise." Well, this process builds in the 4 steps. The first step is initial case assessment. You work with the neutral who is engaged early on, right? It's a back and forth. And with all of the parties, you narrow down the key focus. You might have 20 claims you want to file, but really only 3 of them matter. You focus on those. Then the second phase is information exchange. Working with the neutral, you decide what it is you really need to know, not what you need to try the case. What do you really need to know? Exchange that information. And then in the third phase, you do a risk assessment. You figure out what is your best outcome, your likely outcome, your worst outcome, figure out the probabilities for that and what it's going to cost you to get it. You can put that into a decision tree, come up with a risk adjusted value, overlay that with things like risk aversion, market impact, new developments in your technology you want to get launched while this might be pending in the courthouse for the next 3 to 4 or 5 years or whatever. Figure out where you would like the case, where you think the case should reasonably resolve, and then negotiate.
Yeah.
And
what kind of cases, though, would this apply to?
great question. Commercial, employment, family, personal injury, you name it. It depends on really the lawyers, getting them involved and playing in the process effectively. But, if it's a case where you need precedent, right? It's something that's going to come up over and over and over. Probably not a good case for EDR because you want to have that precedent.
Yeah.
But if it's a run-of-the-mill kind of a case or a case where relationships matter, right? In vendor relationships or competitor relationships, things that matter where you can actually negotiate an outcome better than what the court can provide.
Yep.
Think about it.
Yeah. Well, I've always said that a good reason to get to the table early and start discussions, even though you may not be ready, is because a lot of times people don't even know what they're fighting about.
Correct.
Okay. They just know they're at war. I do mainly family law mediations, of course. And so a lot of times, weeks or months later, people are finally at court-ordered mediation. And that's when they discover, oh, we actually see eye to eye on these issues.
Yeah.
And there's only a few issues that we're at odds about. And I think if people could get to the table first, early on, that might go a long ways towards speeding up the whole process, just so you can then argue, I guess this was phase 2 or you begin phase 2, you can narrow down the issues that you're actually contesting about.
Exactly. You said it very well. I mean, one of the things that we often advise our clients when they walk into our offices at the very beginning of a piece of litigation or potential litigation is, from now on, let me talk to the other side, right? Because you don't want them using what you say in the heat of the moment against you later in the lawsuit. What is one of the basic premises of mediation? It's all confidential.
Correct.
So since it's all confidential, then you know that you can have those candid conversations and not worry about how that might be used against you later. But the key thing here is especially when you're talking about corporate lawyers, right? They have budgets and they have better things to do with their time than fight at the courthouse.
Yeah.
If they know which cases they need to try and which cases are what you just described, it's just a miscommunication or a misunderstanding. Exactly. We now know when and if we have to spend money. And if we don't need to, then we can resolve it and move on to get back to business, sort of.
Yes. Well, a little bit connected reminds me, lately I've been doing a lot of research into ODR, online dispute resolution. And so when we talk about that, we are heavily discussing now preemptive ODR, okay? Putting things in place to help parties not get into conflict in the first place. And so that's sounds very similar to this actually, because same spirit, which is if you can avoid, do so. And if you can avoid and it happens, then get to the table early so you can at least find out what the issues are.
100%. Adam Grant said in a tweet, I forget how many years ago, that the faster we know that we're wrong, the sooner we can get to being right. And this is essentially one of the concepts, right?
Yeah.
Misunderstandings happen all the time.
Yeah. Delayed misunderstandings are even worse.
Yes.
Right? I mean,
Very expensive too.
yeah. Well, and sometimes people, because of pride or ego, may just want to stay in ignorance, and not know. And so, if
Right.
you're listening out there, it's a good thing to try to get to the table, at least open up the door for communication and dialoguing, and that is the first step towards resolution.
Correct.
Okay, I'm going to talk a little bit about AI,
Okay.
only because everyone's talking about AI. So, just give me your candid assessment. We all use ChatGPT and
Mhm.
Gemini now. It's part of our lives. But when it comes to this field, that you've been in this for
Mhm.
decades, right?
Litigation, yes, but not.
Well, I meant the legal world,
Yes.
decades.
Yes.
The dispute resolution portion, now that we're invoking AI into almost everything,
Mhm.
where do you see that heading?
Okay. Well, who knows? is the only
So
thing I can.
then we're done here.
We're done. But it is an interesting question though, because I was thinking about this as I was driving over for this interview. When I was a baby lawyer, I remember spending weekends in conference rooms going through hundreds of boxes of documents, and now we
Yeah.
just upload them into an
Exactly.
electronic system, and we have, a summary and a timeline within a matter of minutes.
Yeah.
So I think that's what it is, right? And just tying it back to early mediations, it used to be you needed to do weeks of review and research because the volume of information was out there and you couldn't digest it quickly. Now, put it into AI,
Yeah.
work through your models with the overlay of the law, talk to your witnesses, take a few depositions if you have to, and now you're ready to negotiate. Much more efficient.
Yeah. Well, that's one of the upsides.
Yes. And I actually used AI this week in a mediation. Actually, it was a post-mediation conversation. The parties resolved, but then they had some sticky points, which happens all the time. And, without disclosing the conversation, I said to one of the lawyers, it sounds like you want to do blah. And she said, absolutely. And so I said, into chat, and I told her I'm typing this into Chat GPT with no names. This is what I'm typing, and she said, "Okay, what does it say?" And we had some outputs, and we presented it to the parties. So,
yeah. Look, as I'm doing my own ODR projects, I'm discovering, I'm telling people, I'm telling mediators, listen, your parties, your clients are already using AI to try to resolve their own disputes, and it's not going to be a weird or scary thing for them anymore when they come to mediation. And we also are bringing it in, and asking it questions. And I don't know how much of it people are going to trust over time, but we'll discover that together.
Yeah. Well, not to dabble in arbitration, but the AI revolution, evolution. I do some arbitrations as well, and one of the panels I serve on in the AAA is the consumer panel, and I've seen some of the, not a lot, but a few pro ses who are using the AI in their arbitration pleadings, and so I'm not sure it's helpful because it doesn't think like a human. I mean, it processes data, but it's not human.
Yes, in Florida, just licensed in Florida as well. And one of the there was a published some cases where pro ses are having a field day with AI. They're just flipping the court system by filing stuff. A lot of it is a little bit of nonsense because they don't know the law, they don't catch it correctly. But because of the volume and the ability for these AI documents, AI LLMs to process information and generate pleadings, they're able to file and file and file, and law firms can't keep up.
Right.
And so this is becoming a real problem.
Right.
It's happened to me, when my opposition, who has no lawyer, decides I'm just going to use AI as my attorney.
Right.
And the bar is going to have to crack down on this. They're going to have to bring some rules, not to keep people away from access to justice, but if you want to have a level playing field that's going to actually be just, you got to have rules. And now this is taking us to places we haven't even thought about.
Well, and you raise up a good point. This is actually an area where if the court systems were to adopt a more robust plan for early mediations, they may be able to address some of that, not all of it clearly, but look, statistically, from 2000 to 2025, the federal court system's backlog has grown by 70%, right? And this is during the era in which mediations have become not just a passing idea, it's a component of almost every case that gets filed, whether it's arbitration or litigation, and that backlog has grown nevertheless. It's not that mediation is ineffective. It's very effective. It's that we are treating it as a component of litigation later in the process.
Correct.
If we were to do what you suggested, let's get an understanding of what it is really fighting about and streamline, have a more bespoke approach to how we want to address the information exchange, how we want to, determine how we're going to resolve this. And let's just face it, the outcomes through mediation are limited only by our creativity. They are not limited by the court systems picking a winner or a loser.
Right.
So they're oftentimes way better than what you could get at the courthouse. So if we as lawyers, as counselors, advise our clients about the benefits, I think that there would be an opportunity for us to help the courts a little bit.
Yep, well said. Okay, let's talk about you being having a former journalism background. I believe you went to school for journalism. And so the journalist's ear in mediation, how has your background in journalism helped you to uncover the hidden interests that might drive settlement breakthroughs?
I don't know. I love writing. And I think writing is an exercise in patience and structure, right? And I think you do the same thing in mediation, right? We, back when I was in journalism school, I remember being taught that we were supposed to be objective and neutral. We were supposed to present the facts, not our opinions. Same thing in the room, right? Trust and credibility are supremely important in journalism. We can talk all day long, different topic about whether we've lost some of that, but in the mediation room, we can't lose that. So I think that kind of training, that kind of approach is really effective.
Yeah, lots of similarities actually.
Yeah.
Thank you for that. And so let's talk about the ADR ecosystem in Texas. So have you seen, mediation and ADR now going to ODR evolve in Texas over the years? And then also, if you could bring in the TJC as well as part of that.
Yeah, I think, when I graduated law school in 1997, there was one mediation class, and I took it, right? A few years ago, I started coaching. I don't do it anymore, but I learned through coaching arbitration at the University of Houston Law Center that there are competitions now for mediation arbitration in law schools. So that in and of itself tells you a lot about mediation, right? It's not just a sidebar of litigation. It's a main component. And students who are coming out of law school now know how to negotiate way better because they're taught way better than what we did when we were coming out of law school. So I would say that is one indication that mediation is here to stay. But let's talk about how it's come. And I do think it has to do with timing. A lot of lawyers, myself included, thought that we needed to do a lot of discovery. We needed to have our case ready to go to trial before we really knew how to get the case resolved. In fact, one of my mentors told me once, he said, the best way to get a case resolved is to be ready to try it. And so we didn't think about mediation until later in life. The courts are backlogged. Parties want fast, right? We have instant gratification all around us on the internet. Amazon delivers on the day you order now. And I think what we see in mediation is this ecosystem at the TJC you talked about, the collaboration. We live in a city where, and this is probably true in many cities, there are a lot of great mediators. And some specialize, and some are more generalists. But by and far, they are very talented, and we're very fortunate to have them as colleagues. I think in terms of what we do for the bar, the more we integrate into the court systems, the more we are able to talk to corporate counsel about how we can help them better represent their clients, more we can talk to law firms and even parties, right, about the benefits of mediation. You know that in Texas, by the way, it's a public policy of the state, Chapter 154 of the CPRC, to try to resolve pending disputes voluntarily through ADR processes. So it's a very important aspect of our industry, but more importantly, it serves the community.
Yes.
I think anyways.
What would you tell a young person finishing law school now about mediation compared to how it was back in the day?
It's more accepted now. You don't go to trial now without first mediating. And let's face it, there was a day when we didn't even have discovery. And now discovery is a key component of every case. I think mediation is taking a different trajectory, but similar in that regard. And I think that it's only going to get more integrated as time goes on, out of necessity,
Yep.
frankly, but also because it works.
Yeah. Well, there's also a backlog that we can't, ignore. And
Yeah.
only conflict resolution is going to help eradicate that.
Well, I would say too that I think people are smarter than they give themselves credit for, and they just need someone to help them communicate, because this reactive devaluation, it's real. If I'm mad at you, I really don't want to
Yeah. Talk to you. Yeah.
talk to you. Yeah.
Yeah.
So
Lots of things. All right. So is there anything I didn't ask you that I should have asked you?
no, I don't think so. It's been you've done a really thorough job of my background. I'm kind of surprised that you knew some of the stuff about what I've done.
Well, thanks to my AI. But no, I Googled you and had to learn a little bit about who I'm going to be speaking to.
All right. Well, you did a good job. Tell us a little bit about yourself. How'd you get to Houston?
Well, I joined a program called Teach for America years ago, and when I finished college, undergrad, decided to go teach, and I've been here ever since. I taught for a few years, and then went to law school, and now graduate history. But I'll be here, alongside you and all the other colleagues. One of whom I won't say her name, stuck her head in the window a second ago, and so I'll go say hi in a second. But yeah, folks, come out to TJC. This is where we are.
There is one thing I want to say about,
Yeah.
and I almost forgot about it. It's super important. The American Arbitration Association is launching a specialty EDR panel, and I'm privileged to work with Peter Silverman and Michael Hallwash and Ann Jordan and Tracy Frisch in the background, trying to help pull that together. And so very shortly, the American Arbitration Association is going to be offering trained EDR neutrals to help parties through that process at no additional cost.
Okay.
I mean, there's not going to be a special AAA fee. You just pay your neutral and move on, just like you would any other time. So really excited about that. And I just want to make sure that I say that, because it's going to be launching probably around May of this year.
Okay. Well, I'll definitely put that information on the blog post that we're
Yeah.
going to write about this conversation today. So thank you so much.
Thank you.
Felicia.
Great.
Appreciate it.
Likewise.
All right, everyone, check this video out and all the other ones on LMIpodcast.com. And of course, the YouTube channel on youtube.com/@LMI Network. All right, guys, take care. Until next time. Bye-bye.